All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning, everybody. Welcome to the Arizona Court of Appeals for Division 1. I am Judge Jacobs. To my right is Judge Perkins, and to my left, your right, is Judge Weinsweig. We are here for two oral arguments today. We'll briefly recess between. The first oral argument is in the case Herold versus Prey. As you probably know, we record and live stream the proceedings, so please state your name and state the name of your client when you start your presentation. So we'll have that for the record and for folks who are perhaps watching at home or later as well. You have a maximum of 20 minutes per side, as you know, although you are not required to use all of your time. We ask you, if you're the appellant, to keep track of your own time. If you want to reserve any, that's really kind of up to you, although we'll remind you if you state a number to the extent possible. Please mind your own time, and keep in mind as you present to us that we have read the briefing, we have studied the record, and we have discussed your case in conference this morning at 9 o'clock. So with that, if appellant would like to proceed, you may proceed.
Thank you, Your Honor. I had asked for and been given accommodation to stay because I have a partially torn Achilles, so I appreciate that, first of all. Your Honor, David Allen representing the plaintiff and appellant, James Herold. Mr. Herold is present in the courtroom behind me. We start with the fact that a purchase contract, such as the one in this case, may be assigned by a purchaser unless it's subject to certain exceptions, which I won't talk about here because nobody claimed they ever were, and the exceptions don't apply. There's no dispute in this case that contrary to the erroneous advice given by Ms. Ballard, the seller's broker, to her client, the sellers, that this particular contract that we're here on today could certainly be assigned by Ms. Davis as the buyer and the contracting party to anybody, to any person or any entity, including, as was the case here, Mr. Herold. This then raises two issues that I'm going to focus on this morning. The first issue is whether the contract was in fact validly assigned from Ms. Davis to Ms. Herold. And the second issue is whether or not Mr. Herold complied with the notice of cure requirement in the contract, or if he did not, would doing so have been futile and thus excused. Turning to the first issue of whether or not the purchase contract in this instance was validly assigned, we start with the fact that an assignment can be either oral or written, and in this case, actually both things happen. We start with the oral assignment. There was no contradiction in the evidence given by the testimony given by both Mr. Herold and Ms. Prey that they were waiting to do the assignment until Mr. Herold figured out how he was going to take title. He was originally contemplating having a partnership or another entity, but at the end of the day, he decided to take title himself. And about a week before the close of escrow, he and Ms. Davis, according to both of their testimony, had a telephone conversation in which it was discussed that, okay, the contract is now being assigned. Matter of fact, the words that Ms. Davis said she used were, I am transferring my interest in the contract to you, Mr. Herold. And that was always the agreement. There are no magic words that are required in order to accomplish an assignment. They both testified that's the conversation they had, and that's what happened. And furthermore, there was consideration that was given to Ms. Davis for her participation in this process. She kept track. She testified. There's no refuting that she kept track of her time, and Mr. Herold paid her for her time. Furthermore,
Counsel, did the court determine that it was not credible that the agreement was assigned, and can you speak to that?
Yeah, I will. The court did say that the court found that it was not credible. However, a couple things on that. First of all, the court gave no explanation for why it was not credible in view of the fact there was nothing to show that it wasn't credible, no contradictory evidence, nothing else. Secondly, and very importantly, you have to look at the circumstantial evidence in this case, which is overwhelming as to the way this deal was structured. They both testified, the testimony was uncontradicted throughout the trial, that the whole The whole way this deal was structured was that Ms. Prey would go under contract and eventually would assign to Mr. Herold or some entity. That's exactly what happened. No attempt was made to keep it a secret. There's correspondence from the lender early in the game talking about Mr. Herold obtaining the loan. Mr. Herold went out and he did obtain the loan.
Counsel, let me ask you, the addendum, let's focus on the addendum. At trial, Davis said the addendum was confirmation of the oral assignment, and your position in the brief is very clear that it memorialized the oral assignment. Is that correct?
Our position, Your Honor,
Or
is
it's
that...
further evidence?
Excuse me?
It's further evidence of an oral assignment.
Yeah, our position at trial was and remains now that we believe that the oral assignment was the assignment that took place. However, and that the addendum would be then a confirmation of that assignment. Or if you want, a memorialization in writing of the oral assignment. But even if it's determined that there was no oral assignment, even though the evidence is clear there was, but even if it's determined there's no oral assignment, then you have the written assignment. So one way or another, this contract was assigned.
Well, so let's focus on the addendum.
Okay.
Why isn't the addendum a novation?
Because the addendum does not change anything other than the identity of the buyer. When you have an escrow situation, a contract, such as in this situation, and the seller transfers their claims to the buyer, their rights to the buyer, then you have a new buyer. And this contract, which is the form real estate contract, even contemplates specifically that prior to close of escrow, the name of the buyer shall be specified. All that happened here was that if you look at the language, and certainly we're not going to argue this is the most artfully drawn document. But nevertheless...
But what are we to do with the wording that says that the contract should have read?
That was wrong. At the time that the broker, Tiffany Lambro, Mr. Herold's broker, drew this up, she was also mistaken, as was Ms. Ballard, thinking that there has to be the words "or nominee," and that she was worried because that's the position Ms. Ballard took. She was worried that maybe she messed up the deal, and therefore she put that language in. But that's totally superfluous, meaningless language, because as we all know, there is no requirement for a contract to say "or nominee" in order to give the buyer the right to assign it.
But should the word should have read seems to indicate is pointing back at the sales contract, and so something should be different that's in there right now. It should have read, and so why isn't that a contract, a modification of a term? Because as I said, it's superfluous language. The fact that it says it should have read R.O. Davis or nominee. Isn't it evidence of either a contract modification or a novation? I'm not saying it's conclusive evidence, but it could go that way.
Well, I think when you look at the totality of it, though, and you look at what the purpose was here, the only purpose of this addendum, Your Honor, was that first of all, the lender, who was making the loan to Mr. Herold, obviously wanted the property to be taken in Mr. Herold's name. The escrow company needed to be instructed how to fill out the deed, and therefore this addendum accomplishes that purpose of telling the seller, okay, you need to sign this because the deed is going to go in the name of the buyer. The language in the contract specifically...
But I guess the only point I'm trying to say is, there's lots of evidence in favor of an oral assignment, including the two people who were party to it, talked, no one was listening in on that call, the agents moved forward as they were supposed to move forward. All I'm trying to get you to concede, maybe, is that the addendum is evidence, might be construed as evidence against an oral assignment, given that it was to confirm or memorialize the oral assignment.
Well, I guess potentially you could look at it that way. However, I think when you look at the totality of it, I think very critical evidence that the court totally ignored is the reaction of the seller's agent when she received the addendum. What did she do? She immediately contacted her clients, the Preys, and said, Davis is trying to assign the contract. she didn't say they're trying to change the contract and make, put different terms in. What she said was, and she testified to this, and Mrs. Prey also testified to it, that when this addendum was presented to Ms. Ballard, she immediately called the Preys. I think, actually, Mrs. Prey is the one she always dealt with, but she immediately called Mrs. Prey and said, just so you know, Davis is trying to assign the contract. You don't have to agree to it. Now, we know that was erroneous advice, because in fact, she did have to agree to it, and pursuant to the specific language in the contract itself, which says that in the event, it says that and this is in paragraph 6C, small 2, at line 258 on page 7 of the contract. It says that all documents necessary to close this transaction shall be executed promptly by seller and buyer in the standard form used by the escrow company. This was a standard escrow company form. This was something that the seller had to execute. Another thing that's pretty critical here that we shouldn't gloss over is Ms. Ballard, that everybody, the lender, the escrow officer, and Mr. Herold himself, and all the documents clearly show that Mr. Herold was ready, willing, and able, all set to go to close this escrow.
So counsel, let me ask you if you agree with me on 2 points. Regardless of that clause you just read about that they have to finish, they have to sign everything, would you agree with me that if it was a novation, the Preys had to consent?
If it was a novation, okay, well, I guess I'll...
So a novation is one standing in the shoes of the other, and the other one leaves the building.
If it's a novation, I mean, honestly, I haven't looked at that because the defendants never raised that as a novation.
So let me say how a contract if it's a modification of the contract, that is a material term, the Preys consent was needed, right? Or
For a modification that changes, and this goes back to the law that I started with, which is that every contract can be assigned unless it's contrary to statute or public policy, that's not the case. Or if it's precluded, that's not the case. Or if it changes the burden or risk to the seller. That's what you're getting at. But there's no change here to the burden or risk to the seller. The seller testified consistently, we just want our money. We just want to close this deal. The fact that it closes in the name of Mr. Herold as opposed to R.L. Davis, as opposed to ABC Corporation, doesn't matter one iota. The seller is getting what they bargained for, and there's no additional burden on the seller. There was no carryback, unlike the deal that they subsequently made. There's no carryback here. It was cash out to them. And so therefore, I don't think there's any way to say this is an ovation because it doesn't change anything as to the seller. The only thing that changes is the name that's on the deed that the seller signs. But that's of no moment to the seller, and the seller so testified.
How does credibility fit in? You had said that there was no evidence, or the court didn't explain it. I mean, the court did explain. I don't know how good the explanation was, but the court said the testimony is inspecific as to where it happened. I think there were 3 things, and I can't get them off the top of my head. How does that fit in to the case?
I think the way it fits into the case, Your Honor, is that the trial court judge did not understand that this is a normal procedure in a commercial transaction, which was testified to by both the escrow officer and the lender. The trial court judge, in his comments, repeatedly made reference to how this was somehow underhanded or nefarious, the fact that the contract was entered into by Davis with no intent herself of closing that deal. She always intended to assign, and the close would take place through the assignee. The judge, and this is very commonplace, but for whatever reason, and I think that's the answer to your question, the judge didn't like it, did not like it, and so chose not to believe the overwhelming testimony that this was the way this deal was structured from the beginning. There was nothing wrong with it, and the parties, in fact, acted in accordance with that all the way through, including the oral assignment and including the execution of the addendum.
And so you said overwhelming, that leaves a sliver in the other direction, that there's evidence that it wasn't an oral assignment, and specifically the addendum?
Okay, well, if you want to believe that this was never the plan, that Davis was always going to buy the property, that Davis perjured herself, even though she's not a party here and has no interest in, would have no interest in doing that she perjured herself, that Herold perjured himself, and that all the testimony regarding the addendum, including the belief of the seller's own agent, that this was an assignment, if you want to throw all that out with the bathwater, so to speak.
No, I wouldn't throw it out. I certainly would. I mean, we have to look at the totality of the evidence.
Of course.
I think the question is, if there was no addendum, maybe there's no evidence in favor of your opponent. But there is an addendum, and the addendum's not clear.
The addendum, I think, is clear to the extent that what it says is that the buyer now is Herold, and that there's no release from liabilities of Davis, which is what that was their argument. They never argued novation per se. They argue, well,
That is novation.
Davis is released, but Davis is not released. There's nothing, in order to be released, there'd have to be language releasing her, and that would fly in the face of the specific language in the contract, which is in paragraph 9N on page 11, that an assignment, that in the event of any assignment, that the named seller, in this case Davis, is not released. And so it's specific, it's very clear she was not released. So, yeah, I mean, I guess you could take any situation and, kind of look at it a certain way, but the evidence here is, and I have to use that word overwhelming, this was always the transaction that was contemplated. The trial judge didn't like it for whatever reason, but this was always the transaction that was contemplated, that Davis was going to enter into the deal, that Herold was going to decide at some point. Herold applied for the loan, which he did. Herold was going to do everything as if he was the buyer, and then at the end, he was going to determine, is he taking it in his own name, is he taking it in a partnership name, how's he taking it? He never had any intent to buy. Davis had never had any intent to buy. This was always the structure of the transaction. I don't think and you could say, well, they blew it, they didn't do it the right way, but I think they did. They had the conversation, and they had this document, and again, I'm not going to sit here and say it's the best example of legal drafting I've ever seen, but it's prepared by a real estate agent, and it was understood. That's critical. It was understood by the other real estate agent to be what it was.
So you only have 4 minutes and 14 seconds left. I don't want to monopolize your time. Please go on to the other arguments.
Okay, thank you.
Actually, could you comment on the statute of frauds argument that was raised in one of the briefs? Whether it would have any
fraud argument?
The statute of frauds.
Oh, the statute of frauds? This assignment was an assignment of a contract right. It was not the assignment of it wasn't the sale or transfer of a piece of real estate. It was, and the law is, and I don't have the cites right in front of me, but they're in the brief. The law is very clear that all assignments of contract rights, such as the right of a buyer under a purchase contract, are freely assignable, unless there's some reason not, and there's no statute of frauds of application there. Okay, well, I see I only have about 3 minutes left, which is what I reserved, so I guess I'll stop and just use my last 3 minutes to try to cover whatever I can.
Thank you, counsel.
May it please the Court, Scott Malm of Gus Rosenfeld on behalf of the appellees defined as the Grabansky defendants in this case. They are the current owners of both the bar and the real property that is at issue. My intent is to reserve 10 minutes for my colleagues to address the specific claims involving them. I'll be addressing the contract assignment issue and also the notice to cure if that comes up.
So it's not going to be parroting the same thing?
What's that?
It's not going to be parroting the same arguments?
No, we're not parroting.
Okay.
No, because there's separate damages claims against the other
Okay.
parties, and that doesn't involve
go
me.
ahead.
And Mr. Moyer also raised the statute of frauds issue, so if that question comes up, I will be deferring to him. As to the first issue that I'll address, which is the no contract assignment, credibility was incredibly important here in this case. This was not a normal transaction. Literally on the other side of the wall is the competitor. Based on a false statement in that notice of intent, R.L. Davis saying, I intend to buy this, my clients gave up their personal financial information to the competitor who's literally on the other side of the wall.
So you're arguing there's no contract, no sales contract, you're meeting of the minds argument?
It's not, there was a,
It was a signed contract, and it was performed up until close to the end of escrow. How is that not a contract?
Right, R.L. Davis signing a contract with the Praise, no, we've never suggested that that wasn't a contract. It is signed. We've never argued that it wasn't a contract. The issue was it assigned then to Mr. Herold to be able to enforce it? If it was not assigned, then as a matter of law, he's not the one who could enforce it, only R.L. Davis could.
Okay, well, I must have misread the briefs because I thought there was some meeting of the minds argument that Herold was standing off in the wings, and so they didn't really know who they were selling to. I thought that was your first argument. But
It's definitely not been my first argument.
okay.
I'll wait if Mr. Moyer or
I'm
somebody
sorry,
else has, but it's definitely not my
Sure.
first argument. The issue for us is if Mr. Herold was never the recipient of that assignment, then he never had the right to come into court to sue my clients for specific performance
Okay.
to get the property and the bar. So credibility was lacking. You could go with that. You could go even with the statement when the question was asked, who are the buyers? And the answer was a group of California investors. That's a far cry from the guy who's on the other side of the wall of you. These are the kinds of things that the judge was very offended by in terms of credibility of whether to believe R.L. Davis and Herold as to this alleged oral assignment. But let's even move beyond the credibility issue. There's written...
So you're saying that the oral assignment, the judge could just find it non-credible based upon the judge's distaste for concealment in the procurement of the original contract. That's what you were saying?
That is our argument, because that goes to credibility. If somebody is going to...
Don't you need evidence on the other side of there not being an assignment, aside from the fact the judge just sort of finds distasteful one set of litigants?
Well, it's not just distasteful of the litigants, it's distasteful in the lying that occurred. So we're not just saying we don't like them because they're, they cheered for a different team or something like that. No, they lied about the transaction. R.L. Davis lied about having an intent. She signed the intent to buy.
But not everybody else did the same lie, right? Not all the people whose testimony would be disregarded under your position were part of the lie you're citing, correct?
What I'm saying is the person who was lying is the person that they're saying should be trusted for the oral assignment. The lying was R.L. Davis. She supposedly is the one who signed the letter of intent that we now know is false.
So would you agree with me that the contract allows for an assignment?
Absolutely, no question about it.
Oh, okay. So if there's no letter of intent and everything else is the same, what's your position?
Well, there was more than just the letter of intent. It was also the Herold instructing his real estate agent to tell the parties and whoever might ask about this transaction, don't let them know that I'm in this transaction. That is another bit of evidence in addition to the letter of intent. So there is also more. You also mentioned the addendum. Let me give you some more documents. It was trial exhibit A33. This is of July 31st, where they're talking through, this is an email from Herold's real estate agent saying the contract and loan have to be in Jim Herold's name. This is when the addendum is flying around. There's no email or communication that says there's an assignment. There's been an assignment, and you know what? It's not good enough to satisfy the lender. We've done an assignment. There was an oral assignment. There's none of that you would expect in that kind of transaction. And most importantly, it is A51. That is the bill of sale that was signed by R.L. Davis on July 31st. So if she had orally assigned the transaction to Jim Herold the week before close of escrow, then why is she on July 31st signing as the buyer? That would be inconsistent. So it's not just credibility issues, it's the actions of the parties around the relevant time.
So let me ask you a question. Are you familiar with the Chilson family case, Supreme Court 1990? Doesn't that say that mutual assent is based on objective evidence, not the hidden intent of the parties?
Sure, yes.
Okay.
Mutual assent.
Right.
So it would be mutual
So you're saying
assent.
there is mutual assent here?
There's mutual assent between buyer and seller, R.L. Davis
Right.
and the Praise.
And the contract includes an assignment clause.
Allows it to be assigned. So now the question is, did, as a matter of fact, in fact happen that there was an oral assignment? Did R.L. Davis actually say that to Herold? And the court said, credibility, no, based on the lies and other things, but also the written documents that would be inconsistent. You mentioned the addendum. I'm mentioning the bill of sale that was signed July 31st by R.L. Davis as proof that there had not been an assignment the week before, because if there had been, she shouldn't be the one signing the bill of sale document. And there are other emails from their real estate agents. Trial Exhibit A33, for example, is one that that makes no mention of an assignment in the context where you would think that would be what they would explain. If I may, I would like to go to the addendum issue that you mentioned before of why that's not an assignment itself, because as you said, it is modifying. It is specifically saying that this is additional terms to the contract, and specifically, sole buyer is the key language. That didn't come up in the first round of questions, but I wanted to highlight that language because when that says sole buyer, that goes to the issue of modification or novation that you were talking about, Judge Weisig, that it makes it different. Now there's no question if they just simply did an assignment, buyer would have been R.L. Davis, who assigns to Herold. The original buyer would be on the hook to be sued, and maybe then you could also enforce it against the assignee. But when you do a modification that is now Herold is the sole buyer, you have a different relationship. You've taken away one person that could be sued in this situation.
Well, could you? Because the contract said that Davis can't be released, hard stop.
Exactly.
So it doesn't matter what they agree.
Unless you sign an addendum that says Davis is out.
But the Praise didn't sign that, so...
Exactly.
Right, so the contract says she can't get out, and that there's nothing that can be done about that.
Correct. So therefore, the addendum was not an assignment.
Well, you could have an assignment. In fact, it envisions that precisely. It says, I read it to say you can have an assignment as long as Davis is not off the hook.
The contract can absolutely be assigned without Davis being off the hook. That goes to what was the purpose of the addendum. The purpose of the addendum wasn't to implement an assignment. It was to replace, as you said, the name of Davis with Herold's name. So now there is a, quote, sole buyer. That's the key language there, that no longer is it under the regular terms of the contract where you have assignor and assignee, both potential parties to be sued if there's an issue. Now you have only one buyer.
So it purported to be a complete substitution?
That's what it appears to be when it says sole buyer.
Okay, that's a novation.
Novation, modification,
Okay.
yes.
Right. Doesn't a novation require actual language, the word release, so that it would also say what it said, but then it would say Davis is released, and that's not in there?
Well, that's the point of, I think you're taking it beyond just a modification into the law of novation, so that is why we've never really argued the novation.
What's the modification short of novation?
The modification is
Assignment of
replacing
novation?
a sole buyer. So if
That's
you want,
novation.
That's novation, and, okay, so that's novation, then that's the release, because you're saying this is the sole buyer. Then who's the buyer on
So
this
it's
contract?
silent as to liability, that means...
Well, it's not silent as to liability, because under the contract, the buyer is the one who can be sued, but there's no, the addendum isn't saying there's an assignment to somebody else. It's only giving us now one name. If the Praise would have signed that addendum, there would have only been one name for them to have sued, and that's Jim Herold, the person that they sure didn't trust and probably didn't want to even be in that transaction with them once they realized and had their reaction.
Isn't the case here that they didn't have to, the Praise didn't have to sign, and Herold could have just moved forward, and his cure letter could have just said, close escrow, I'm going to sue?
I am running out of time for the other parties, but just to address the notice of cure issue, it could have if they had said there was a non-compliance. If they would have said this contract has been assigned to Herold, nobody specifically said it had been assigned, and nobody said there's non-compliance with the contract by you not recognizing that assignment. All they said was, sign this addendum, get your money, don't sign, you get sued. That's a threat. That's not a notice.
Well, I think it's a notice of something that's not actually the breach. The breach is not going forward to close escrow. You didn't have to sign. Your client, Praise, didn't have to sign.
Correct. The Praise, our seller, did not have to sign. Correct.
Okay.
If I could leave the rest of the time for counsel. Thank you.
morning. May it please the court, my name is Wade Bergeson. I represent Suzanne Ballard. Suzanne Ballard and Brooks Clark and Associates, who's represented by David Smith, who's in the courtroom along with me today, were both the defendants on the intentional interference claims. My intention is to reserve, or use only 5 minutes. Our plan was to have 10, 5, and 5, and we're already a little bit off at our time schedule. Thankfully, it's not me this time. Because of the limitations of time, Your Honor, my intent is to address the attorney's fee issue, and specifically, the court had awarded fees to Ballard and Brooks Clark. Following trial, applications for fees were submitted to the court. While Mr. Herold did object to the fee applications, it was only as to the entitlement of the Ballard and Brooks Clark defendants to an award of fees. It wasn't as to the amount or the reasonableness of the fees sought. So for purposes of this appeal, reasonableness and amount are not issues. With respect to ARS 12349, the opening brief is entirely silent on 12349. Again, for purposes of this appeal, they waived and abandoned that issue, and the court should consider the arguments raised for the first time by the appellant in the reply brief. Under 12349A1, the court can award fees when a claim is brought without substantial justification. Based on the testimony at the trial court, 4 days of testimony and the trial judge's findings of fact, not only was there not substantial justification, there's no justification whatsoever.
If we were to find there was a contract, that much, isn't that justification? I mean, do you have to win it all to be able to get there?
No, because that doesn't get you there. Whether or not there was a contract, which is certainly a point in contention, there is a dispute about whether or not there was a contract. Again, the meeting of the minds part that you were speaking to earlier was that there was never a meeting of the minds between R.L. Davis and the Praise, because from day one, R.L. Davis never had any intention whatsoever of ever completing that contract. It's further compounded by the problem of the addendum. As we know, I mean, so we have the existence of a valid contract. Okay, that's in question. We have the interferer's knowledge of the existence of the valid contract, and that has to be the valid contract between the appellant and the Praise. Here, the only way that you get to a valid contract is if addendum 3 was actually an assignment.
So I don't want to get you off the fee point. Let me ask you then, so if you're arguing reasonableness, 12341, are you abandoning the 01 that this was a contract, so we have a fee shift to the prevailing party?
No, Your Honor, I think they're recoverable and they're justifiable under both of those provisions.
Can you tell me a case today in which a party was awarded fees under a contract that they weren't party to?
That they were not party to?
Right, that they didn't sign, that they didn't...
You know, there is no Arizona case, the Arizona State case, that talks about the facts that are specific to our fact pattern. So in my brief, I cite the Arizona District Court case of Killingsworth, which again was a memorandum decision from 2006, certainly not precedential, but it is factually on point with our case. And in Killingsworth, you have an employee, a disgruntled employee, that sued his employer, State Farm, and in addition to suing State Farm for breach of contract, promissory estoppel, a plethora of other causes of action, sued his coworker for intentional interference with contract. In that case, the Arizona District Court found that there isn't a distinction between employee and employer, about agent and principal, that the claims against the coworker for intentional interference really collapse into the claims of breach against the...
Yeah, I understand your argument, but I also want you to, if you can concede, for us to find in your favor, we would have to hold for the first time in the history of the state that someone not party to a contract is entitled to fees under 34101.
Well, if you appreciate that in this case, we have a very unique circumstance, much like the uniqueness in Killingsworth, that at all times Ballard and Brooks Clark were the employees, the agents of the Praise. And if you look at the claim that was brought against Ballard and Brooks Clark, it's really that they should be responsible for the alleged breach of contract by the Praise not carrying through with the Davis contract that may or may not have been a contract and not complying with the addendum 3 that, if it was anything, wasn't an assignment. But going back to substantial justification, Your Honor, It's not, there's no substantial justification if the claims are groundless or not brought in good faith. And in this case, they were always groundless. Okay? Because in order to have intentional interference, even if you say there was actually a contract, even if you say there was actually an assignment under Addendum 3, that doesn't get you to intentional interference. You still have to show that there was intentional actions on the part of the supposed interferer and improper conduct. So an intentional action by the interferer to cause or induce a breach of the contract and an improper conduct at that. You have to look at those in conjunction, and they just never had that. Because 25 months before trial, on November 20, 2020, when they amended that complaint, when all discovery was done and they should have been set in case for trial, Herold put the brakes on it and said, no, we're going to amend this complaint. We're going to assert the new claims, the new intentional interference claims against these two new defendants, and we're going to do that, according to them, solely because of a snippet of deposition testimony from September 16th, 2020, by Mrs. Prey that said, golly, yeah, I guess as I sit here today, I don't hold any ill will towards Mr. Herold, no animus, and if I had known I was going to get my money, okay, fine, I would have sold it to him. I would have signed Addendum 2. As the trial court found, as we explained, as the rest of that deposition transcript actually clarifies, that was her mindset on September 16, 2020. It was absolutely not her mindset on July 29, 2019.
So, Mr. Burgess, you only have 2218. I don't know if
No substantial justification, Your Honor. The bad faith is that they went to trial with the facts they knew on November 20th, 2020. They didn't develop a single new fact. They didn't uncover an additional piece of evidence. They didn't take one piece of discovery in 25 months prior to trial. They always knew that those claims lacked justification. As far as delay and expansion, two new defendants, two new claims. Their claim is, well, it was Brooks, Clark, and Ballard that actually expanded and delayed because they had the temerity to hire their own attorneys to represent them and defend them from these meritless claims. That's not what the Hohokam Resources cases said, the one they cite in support of that proposition. There was always going to be the same amount of expansion, same amount of delay. Two new defendants, two new claims.
Thank you, counsel.
Thank you.
Your Honor, may I answer the one question about a case for the attorney's fees and not being a party to the contract? Could I just answer that real quick?
We got to put you back on the clock to do that.
Yeah, we're putting on the clock.
Okay, please go.
Just real quick, I cited it on page 34 of my brief. It is the Characia v. General Motors Corporation case, 212 Arizona 18 at paragraph 47. It says a successful party need not be a party to the contract forming the basis of the award. So that is the case that we've cited for your review on. You don't have to be, because my clients technically weren't a party to that contract either, but were awarded attorney's fees because the specific performance claim did arise out of that contract.
Thank you, counsel.
Thank you.
Oh, sorry.
No, that's okay. It's fine.
Okay, then. Would you like to take the last minute?
I will be brief.
When I did this in your place in practice, I got 1 minute and 20 seconds, so I feel you.
Thank you, Your Honor.
Okay?
May it please the court, my name is Ken Moyer. I'm attorney for Appalese Prey and Desert Martini and Tavern Corporation. I was here to address the remaining claims, which are the declaratory judgment claim against my clients, breach of covenant of good faith and fair dealing, monetary damages, and specific performance. But given the time allotted, I'll make a comment. Your Honor, you raised an issue about the statute of frauds, and that was an argument that I had raised in my brief. Mr. Allen argues to the court that because this is a contract right that is assigned, the statute doesn't apply. We cited in the brief to 72 Amjur Second Statute of Frauds, Section 64, which says, the interest of a vendee under an executory contract for the sale of land for purposes of assignment to a third party is generally regarded as an interest in land, and the interest cannot be transferred by an oral agreement. And if a contract is in violation of the statute of frauds in Arizona, it's void. So the position is the assignment, and granted, my clients weren't part of this oral assignment or claimed oral assignment, but it's void. It's not enforceable.
Okay.
So, and I'm out of time.
Thank you for the answer. Unfortunately, you are. And let's please set this back to 4 minutes if we could, on the other side.
Thank you.
And that'll equalize that. Perfect. Okay, when you're ready, counsel.
Okay.
Thank you. Really quick on the statute of frauds, that was not a basis of a finding against my client, and it was not appealed or cross-appealed or anything, so I don't think that's properly before this court. With respect to the award of attorney's fees, just a couple comments on that. As the court recognizes, those are tort claims against Ballard and Brooks Clark, and I cite the court in my brief to the Bar J. Bar Cattle Company versus Pace case, 158 Arizona 481, which makes it clear that fees are not awardable in this kind of situation. I would also point out that the broker, Brooks Clark, didn't even request fees in their answer. As to the fees that were awarded to Grabansky and McKim, who are the only reason that Grabansky and McKim were in this case is because they bought the property at a time after the list pendants had been recorded. The title company didn't pick it up. The title company obviously gave them a defense, but that they were brought in for debt relief because when we get specific performance, which I believe Herold's entitled to, in order to award it, you have to have jurisdiction over the party who now has title, which is Grabansky and McKim. They chose, first of all, that's a contractual claim, which is debt relief, which is the only thing they're sued for. There's no claims of wrongdoing against them. It's just a debt relief claim. The statute does not provide for the award of attorney's fees in a debt relief claim. Further, as a matter of practicality, they could have avoided that whole problem by simply tendering their defense to the Prays. When the Prays sold them the property, in the contract, it was presented at trial, in the contract, there's language in there saying that the Prays will indemnify McKim and Grabansky from any claims of this type of nature. So they chose, and their insurance company, whatever, chose to come in and to spend a bunch of fees, but they're not entitled to any of it. There's no statutory or case basis to give them attorney's fees on a debt relief case of this nature. The last thing I want to talk about with my last, I forgot to push my stopwatch here, I'm sorry, but I probably have a minute or so. The last thing,
You have a minute 55.
excuse me?
You have a minute and 55.
Okay, thank you. So the last thing I want to use on that is the no secure issue, which we didn't talk about, which very surprisingly to me, the judge kind of glommed onto at trial. You have to look at the events, they're very critical. July 29th, Herold and Davis signed Addendum 3 and present it to the seller. July 29th, later in the day, Ballard meets with Prey and wrongfully tells her that she doesn't have to sign it, the seller doesn't have to agree, and also fails to tell her that this deal is teed up and ready to close by Herold, which she admitted she knew at trial. Later in the day yet, Miss McKim, the ultimate buyer, who used to work for the Prays, happens to come by the bar, according to the Prays' testimony, or Mrs. Prays' testimony, happens to come by the bar and says, hey, by the way, if that deal blows, I want to buy the property. Well, now the Prays have a built-in buyer. So guess what? At that point, on July 30th, the next day, Ballard sends an email to Lambro, the buyer's agent, saying the Prays will not, all bold and caps, will not sell to Mr. Herold, and follows that up on July 31st with another email saying the Prays will only sell to R.L. Davis. On July 31st, Lambro responds to that saying, sign the addendum and you get $1,180,000 today. Don't sign, you're going to get a lawsuit. First of all, that email, the last email, was certainly sufficient compliance with the notice to cure. There's no specific language required. It just has to give the breaching party at least 3 days of a chance to cure. In this case, they were given much more than 3 days because no action was taken by Herold until much later. And the fact that the trial court found that this was not sufficient because, and I quote, it doesn't say it's a cure notice, and I end quote, is totally unfounded. There's no requirement that it has to say this is a cure notice, and that's totally putting form over substance. Furthermore, it would have been futile in any event, which even the court found when he acknowledged in his oral findings, it is clear, and I quote, it is clear on the day that she found out who the buyer was, on the day Prey found out who the buyer was, she was not going to sell to that buyer.
Okay,
so it would have been futile.
Okay, you're at time, counsel.
Sorry for talking so
No,
fast.
thank you very much for all of your arguments. We will take the matter under advisement. We'll issue our decision in due course. We're going to take a brief recess and then come back for the second argument in a few minutes. Thank you, counsel.
Thank you.